Good morning. I hope everybody is doing well. I'm Holly Schroeder. I'm President and CEO of the Santa Cruz Valley Economic Development Corporation, and we are doing this series of webinars called Scaling Up. We're doing those in partnership with Santa Cruz Valley Chamber, supported by a grant from Wells Fargo. And this week, our topics are sort of about the people aspect. So this morning, you're going to hear from Brian Koegle, who is our attorney in town with Poole, Shaffery, and Koegle, and he's going to talk a little bit about sort of the legal considerations and issues as people look at bringing employees back on their payrolls that might have been furloughed or laid off, or their whatever adjustments they might be making. So I want to thank you for joining us. We have another webinar on Friday that is about sort of the culture and employee dynamic of our brave new COVID world. So I hope you will join us for those. And then on the EDC website, scvedc.org/scaling up, is where you can stay abreast of all of the dates of upcoming webinars as we move our way through the month of May. John Musella from the Santa Cruz Valley Chamber is with me today. And John, do you want to say a few words of welcome?
Yeah, absolutely. Thanks so much, Holly, and good morning, everyone. And thank you for being with us for another one of our Back to Business webinars here today with our good friend, Brian Koegle. My name is John Musella, and I'm representing the Santa Cruz Valley Chamber of Commerce, which represents 65,000 member workforce here in the Valley. On behalf of the Chamber, I want to thank you for joining us, and we're obviously pleased to be here in our second week of this webinar series that we're co-hosting with the SCV EDC and our friends at Wells Fargo. I want to be sure you've registered for this Friday's webinar, as Holly had mentioned, titled Workforce Readiness, Culture, and Communications, which is important as we all start getting back to business in some sense of normality in the business world as we move forward. We're obviously pleased to be partnering with the SCV EDC and are proud to be supporting our business community as we all adjust to this new world. But one thing is for sure, we definitely all need to get back to business and get our economy moving again. I wanted to say a special thanks to our good friend Brian Koegle with Poole, Shaffery, and Koegle for being here and sharing this important information with all of us today. Brian and his firm have been a tremendous resource to the Chamber and our entire business community over the past many years, and we value that partnership and are pleased he's with us today. And with that, I'll turn it back over to Holly and to Brian to continue with the webinar. Thanks so much.
Great. Thank you, John. And we'll go here to our brief slide here. I think Brian doesn't need a whole lot of introduction. He's been so generous with his time in doing many of these webinars, and prior to March, doing many presentations about employment law and the different issues and considerations that companies need to wrestle with and figure out. We're out. He's partner at Poole, Shaffery, and Koegle. And Brian, I am going to turn the controls over to you. As I do that, I want to make sure everybody knows there is a question and answer opportunity. So if you use the question box that is on the side panel, which is, you can expand or contract using the little orange arrow. But please, as you put your questions in, make sure you hit the little arrow send buttons. And as we get to the conclusion of Brian's presentation, I'll be back in order to do some Q&A based on what you have sent in. So thank you. And Brian, it's all yours.
Outstanding. Well, thank you very much to the EDC. Thank you very much to the Santa Cruz Valley Chamber of Commerce. Special thank you to Wells Fargo for making sure that we're able to deliver this wonderful information to everybody in the community. Thank you all for making sure that you're taking time out of your day, because I know that everybody is wondering what in the world we are going to be doing and how in the world we're going to be able to get ourselves back to work and scaling back to business so that we can find our new normal and we'll be able to move our businesses along. We've got a lot of information to go through today. As Holly said, we'll save questions for the end. But if there's an important one that comes along the way, Holly will interrupt me as we go. It's important, I think, for us to start understanding where we are today, because where we are today is not where we were 24 hours ago. And more information has come out as we've come along, such that we need to be able to understand where we are from the opening standpoint at the statewide level, at the countywide level and at the local level. So I've laid out just a few points that I wanted to talk about. First and foremost, I believe everybody who's on the webinar today is a California employer. So we're going to talk about the state of California and where we are. As we know, Governor Newsom announced that there would be 4 stages of opening. What was interesting was that as of last week, he then broke up stage 2 into 2 phases. Phase 1, which began last Friday, and phase 2, which is yet to begin. There are a number of opinions that come about as to when phase 2 of stage 2 will actually commence. We believe it may be as early as this Friday, as late as the end of May. But in phase 2, this is what we all wanted to hear here in the state of California. It's a gradual phasing back in of businesses such that they are going to be able to bring their employees back, begin production or rendering services again, and beginning to get back to whatever the new normal looks like. We're going to talk about the practices and the policies that an employer must have in place before opening their doors in a couple of slides, but understanding that the government from the statewide level has laid out a coursework, what you have to do to make sure that your business is prepared if you are a stage 2 business. Most of the stage 2 businesses revolve around retail and expanding the availability of restaurants. Phase 2 of stage 2 will include an element of childcare and what those restrictions are going to look like as childcare facilities begin to open back up. Why is that important? Well, most employees cannot come back to your place of business if they still have minor children at home, right? And one of the issues we're going to talk about is the fact that if you have had your employees furloughed over the course of the last 6 to 8 weeks, when they return to work, they may still be entitled to take paid leave. And we'll talk about that in another slide or two. The state has laid out very specific objective medical and scientific criteria on which they're phasing these businesses back in again. According to Governor Newsom, as of 2 weeks ago Tuesday, his statement was that he didn't believe that we would reach full opening until after Labor Day weekend. That's September. I'm not talking about Memorial Day. We're not talking about 4th of July. We're talking about full opening not taking place until mid-September. And that's what we need to be prepared for from a business modeling standpoint. Because while we may be able to bring folks back, we are going to have to make sure that we're maintaining space, social distancing between our employees. That may require a retooling of our space. That may require bringing our employees back in different shifts. It also may mean that we're only able to bring back a portion of our employees to the workspace and have the rest of them work from home. But we'll talk about that today. And then finally, as part of the state of California order, Governor Newsom did divert some of the power to the counties in order to make their own decisions on whether or not it makes sense for them to open up faster. I want to make sure something is perfectly clear. Governor Newsom, when he made this announcement, people in the more populous counties thought, oh, this is great. That means that our county is going to be able to make their own decisions. Really, it's guided towards more of the rural counties. Think up north. Think in Inyo and Mono counties. Those places where we haven't seen a rampant spread of COVID-19, there have been few, if any, deaths, and therefore they're able to kind of sidestep the density issues that we have here in Los Angeles and Orange and Ventura and Riverside counties. Now, with that being said, the obligations that were placed upon local municipalities, meaning counties, were rather onerous. They required very low thresholds of new cases. They required 0 deaths related to COVID-19 in the last 14 days in order for them to be able to progress through this system any faster. So we're not holding out a whole lot of hope that it's going to be expedited by any particular county, at least in Southern California. But I will tell you that the panic that ensued yesterday afternoon after Dr. Barbara Ferrer, who is the county's representative, County of Los Angeles' representative on a task force, making an announcement from the Department of Public Health's perspective that they saw an extension of our county-wide, again, Los Angeles County, safer at home order to extend for at least 90 days with all certainty, unless there was a dramatic change to the virus and the tools at hand. The county quickly came out with a statement shortly thereafter to clarify the statements that had been made by Dr. Ferrer. For what they're worth, I put them up here on the screen. It doesn't say a whole lot. It basically just says, we are going to extend the safer at home. It will be extended for approximately 90 days. Everything is going to, we're not going to reopen for 90 days, except for those things that we allow to reopen. And so it left a lot of confusion for business owners. We were not expecting to hear that information yesterday. So there have been a lot of folks, especially on the legal end of things, who have been scrambling to look at what that actually means. This doesn't mean that we're not going to be open for 90 days. I want to make sure that's clear. That doesn't mean that everybody's going to be staying at home for the next 90 days. But it does mean that we're going to have tighter restrictions in Los Angeles County. Why? Because we haven't seen the flattening of the curve that the government officials here in the county want to see in order to bring people back. So for those of you who are in Los Angeles County, and most of you are, you do need to be aware that in the state of California, when Governor Newsom makes an announcement, it is only one part of the puzzle. Yes, you must, as an employer, comply with the statewide obligations for reopening protocols and procedures, but you also must comply with the County of Los Angeles' standard if that's where your business is located. Finally, there are also local standards that are coming out from City of Pasadena, City of Burbank. Last night, the City of Santa Clarita voted to write a letter to the County of Los Angeles opposing the extension of the safer at home order for the 90 days. Each municipality, each small municipality has its own rules, regulations, and obligations. And you, as an employer, as a business owner, are going to be obligated to comply with the most stringent rule. What does that mean? Just because you're in compliance with the California standard does not mean you're in compliance with the county standard. And violations of either of these municipal ordinances or executive orders can result in penalties, both civil penalties and potential criminal penalties. So make sure you're being careful, make sure you're educating yourself on what all of the rules of the road are before you start bringing folks back to work. So now that we know kind of what the horizon looks like, I want to give a couple of big picture items for you to consider before I dive into policies, procedures, and protocols that you must implement in order to be able to reopen in California. First and foremost, communication truly is key. Many of you have heard me say this in multiple presentations before, but I want to reiterate it once again. Your employees are as scared, if not more scared, than you are right now. There is so much uncertainty in what is going on a federal, state, and local level that people are looking for any semblance of leadership, of guidance, of information that they can get their hands on. Now, unfortunately, with communication comes miscommunication or misunderstanding. So you need to be clear and concise in your discussions, in your communications with your employees. I mentioned in a previous webinar that leadership is all the more important in a time of crisis. This is never more true than it is today. Good leadership, good management of a team is essential to make sure that you're restoring the trust of your employees into the operations of the business. And more importantly, it doesn't have to come from the CEO or the business owner. One of my favorite quotes that I have actually posted to my monitor here in my office says, "Leadership is a choice, not a rank." That's a quote by Simon Sinek, an author and a motivational speaker, who basically says, look, you don't have to be the top of the food chain in order to be able to make a difference. So I would encourage that you business owners and HR professionals empower managers, supervisors, lead men and women who work for you in your business to make these statements and communicate with the employees and make sure that everything is trickling out to the line level employees so that they know what to expect. Part of that communication is saying, look, we don't know what we don't know. There's a lot of uncertainty on our level too. And guess what? We're worried about it as well. We think that we've got a viable business enterprise. We're hopeful that we're going to be able to recover quickly, and we need your help, your assistance to get us there. Second, setting realistic expectations. Everyone needs to understand that because of the fear, because of the anxiousness that many people are feeling right now, productivity is not going to be what it used to be before we went into this lockdown. It just simply isn't. You need to have the understanding that expectations on your employees need to be modified in order to be able to create a fair and reasonable welcoming back in order to get the wheels turning again on the bus. Do I think we're going to get back to our normal productivity levels? I do. I actually think we're going to be able to exceed productivity levels in time. Whether that's 3 months, 6 months, or 2 years, I can't tell you. Every business is going to be unique and very different. But setting those expectations for your employees, letting them know what it is that you're looking for from them is very important. If nothing else, you are setting the baseline, an understanding between the employee and the employer, such that if an employee fails to meet your expectations, you've laid the foundation for discipline up to and including potential termination of employment for a good faith reason, a legitimate, non-discriminatory basis. If you set an expectation and your employees don't meet it, you have an obligation to enforce those rules. And that's a tough thing for businesses to do. With that being said, you do have a business to run. Third, re-engaging a distracted workforce. Daily news and information and social media is flowing, and people have so much information at their fingertips that it simply is not reasonable to think that people are going to have 100% focus when they return to work. So with that being said, making sure that you bring people back in and let them know this is your job. We have an intent to get this job done. We need you as part of this. We're going to do X, Y, and Z in order to re-engage you is an important element of the job that you have as leaders in your business. Fourth, restoring culture. This may not be the same culture that you had back on March 18th. Cultures have changed. What used to be a very difficult or onerous burden, having employees work from home or telework, has now become the norm in many industries. What does that mean? Well, in certain circumstances, an employee may come to you and say, listen, I'm having difficulties because of childcare. I'm having difficulties because of, being able to come into the workplace. I'm feeling animosity or anxiousness because I don't want to get ill. I'd like to continue to work from home 2 days or 3 days per week. What used to be a situation where you never had to accommodate that unless it was reasonable under the circumstance has now become the norm. So that portion of your culture may need to shift. Secondarily, how you handle discipline, how you handle productivity issues, how you handle attendance and punctuality may need to be softened, at least in the short term. You may need to have a little bit more consideration for your employees and their needs in this time. Now, does that mean that you don't have the right to enforce the rules of the road? Absolutely not. You absolutely do. But you need to make sure that what you're setting is going to be consistent with the culture that you want to have moving forward. Fifth, patience. And I can't stress this enough. Patience is going to be necessary on everyone's part. We're all standing on edge. We are all working through anxiousness and depressions and everything along the spectrum of mental health issues. Coming back to work, especially for those businesses that have been shut down for the last 8 weeks, is going to be a difficult transition. Management needs to have patience with the employees, and the employees need to have patience with management. This should be instilled as part of your culture as you begin reopening your business. All right, so with that as our big picture, I do want to kind of jump into a couple of items relative. Oh, I'm so sorry, guys. I didn't put that up on my screen. There we go. Now I'm caught up. The reintegration of employees is going to be an essential part of your job as people are coming back to work. And it's not exactly going to be the easiest thing in the world. And why is that? Because we have, over the course of the last 8 weeks, seen employees leave our place of business, either through furloughs, meaning a reduction in hours, a reduction in pay. Some people were taking 10% pay cuts, 25% pay cuts. Some folks were just completely furloughed. They've been let go. They're not working at all, but they are intended to be brought back once the business is able to reopen. And then there are some employees who have been laid off, and layoffs typically do not result in rehire in many circumstances. Now, with that being said, the rules of the road have changed drastically over the course of the last 8 weeks. A microcosm of that is what has been going on with the EDD, that's the Employment Development Department. This is the organization, the administrative agency of the state of California that basically doles out and hands out unemployment insurance benefits, state disability benefits, etc. Over the course of the last 8 weeks, the rules have changed almost on a weekly basis. And as part of this, the concern is the state is trying to make sure that the safety net for employees is in place so that no one falls through the cracks, that everyone is able to keep a roof over their head, food on their table, and keep their children warm. That is the essential function of what the unemployment insurance program is supposed to be. What it's turned into, though, is an artificial incentive for people to stay home. What do I mean by that? Well, many of you know, and you've heard me speak on this before, that as part of the CARES Act that was passed back in April, the states were given an additional sum of money that could be given out to any employee who was underemployed, basically reduced hours or reduced pay, or unemployed. They lost all of their hours and they don't have a job to go to. That provided an additional $600 per week for every employee that was affected. Well, that $600 is given to an employee whether they were making $13 an hour or whether they were making $80,000 a year. And what ends up happening is there is now an incentive for people who are receiving both state disability or state unemployment benefits and that extra $600 a week incentive. It's really difficult to bring back a $15 an hour employee who has to come back and do work and work for less money than they're receiving while they're sitting out on unemployment. The unemployment insurance kicker from the federal government, though, expires on July 31. So it is just a short-term fix. The issue is, as you are beginning to bring your employees back to work, as you're rehiring them, as you're bringing them back off of furlough, as you're reinstating their reduced hours or their reduced pay, employees have an obligation to accept a bona fide offer of reemployment. This is where it becomes essential for you as the employer to make sure that that communication is being given to the employee. And it's not just a phone call. It's not just a text message. This needs to be something that is communicated to your employees in writing. And I'll explain to you why in a few moments when we talk about the PPP, the Paycheck Protection Program. You need to make sure that when it's time for you to bring back your employees, that you put in writing that they're going to be restored to their regular hours, possibly modified hours, the same work, possibly modified work, and when it is you expect them to return. You communicate that to them in writing, and you ask for them to basically respond to you confirming that they're coming back to work. What do we do if an employee says, I don't want to come back to work? I don't feel safe in the workplace. I've got an elderly mother that lives with me and I don't want to be exposed to COVID-19. How do we handle that situation? Well, I tell you to handle it delicately. Unfortunately, the problem that we have is there are folks out there who will be opportunistic, who will take advantage of this circumstance, and many of these people will just say that they're fearful because they want to sit at home and continue to draw that extra $600 per week benefit from the federal government. You as an employer have a right. You have a right to bring your employees back. You can insist that they return to work. And as long as you're taking the proper protocols and steps to protect them in the workplace, they cannot refuse your bona fide offer of reemployment without jeopardizing their ability to receive unemployment benefits. What does that mean? You extend an offer of reemployment. They say, no, I'm not willing to come back. You can report that information to the EDD, and they will therefore be disqualified from continued benefits unless there is a good faith reason for their refusal. What does the good faith reason look like? It cannot simply be, I am fearful for my health. It has to be, I do not have childcare for my child yet because childcare facilities aren't open. I don't have the ability to have care for my elderly parents at home. I am a high-risk individual myself, and my doctor has told me to self-isolate because I have an autoimmune disorder or a respiratory illness, etc., something along those lines. But further documentation and information will have to be provided by the employee to the employer and to the state of California in order to continue qualifying for benefits. Again, I emphasize patience on this. It is a very difficult situation that employers are going to be faced with because, quite candidly, you need people to work in order to produce, in order to serve your clients. If you don't have your staff, you're going to have to go out and rehire. The rehiring process, especially in this time, is going to be time consuming. Getting up to speed could be delayed by 90 to 120 days if you aren't able to find the right person. So be thoughtful, be patient, be understanding with people, but understand that at the end of the day, you as the employer do in fact have a right to insist that your employees return to work if you have the work for them to do. I do want to touch just briefly on the effect of what all this means for your PPP loans. For those who don't know, PPP is the Paycheck Protection Program issued by the federal government. They are loans that are fully forgivable if an employer uses the loan proceeds for a proper purpose, a good faith purpose to pay the payroll of their employees or other expenses that are related to the business, such as rent, utilities, etc. Understanding that the business has the burden to show that they use these funds for a legitimate purpose. You are required to track what the money went for. You are required to show that an employee is receiving their pay because of the PPP loan. What do we do if an employee refuses to come back to work? This is where it became so important for us to document that information, because the government came out with a clarifying statement a week ago Sunday that said, if an employer makes a bona fide offer of reemployment in writing, the employee refuses to come back to work, you, the employer, may then use the wages that you otherwise would have paid that employee, and it will be forgivable under the PPP as long as you hold that job open for them and you allow them to return at a later time. Okay, so it's important for you to be able to have the forgiveness of the loan, meaning you don't have to repay it, in order to make sure that you've documented every effort that you've made to reinstate your staff. The other point of the PPP loans that I wanted to touch on just real briefly is a question that had come up on one of our last presentations regarding the taxability of this income. There is a battle afoot right now in Congress because the way that the IRS has interpreted PPP monies is that any purpose that you pay those sums for, payroll, rent, utilities, are not a deductible expense from your business. Now, that would make perfect sense as long as the PPP monies that are received are not deemed to be income, that you have to claim that as income. And that is what was written into the original CARES Act. And right now they're seeking clarification from Congress to oversee the issue from the IRS to basically say, look, if you received a $600,000 PPP loan, you do not have to report that as business income at the end of the 2020 tax year. Stand by, stay tuned, because this is kind of one of those things that's unfolding as we go. It is part of what is being proposed currently under what we'll call the Stage 4 bill, the HEROES Act, that is currently being argued in Congress as we speak. I'm not going to spend a whole lot of time talking about the HEROES Act today because it is consistently changing and flowing right now, so we don't have any clear guidance on what those numbers are going to look like, other than the fact that the proposal is an additional $3 trillion in debt for stimulus to the local economies. Finally, I want to point out that if you are in Los Angeles County, there are certain right to recall and worker retention obligations on businesses in specific industries. Hotels, hospitality, restaurants, and agriculture are all subject to these issues. What does that mean? It's similar to what the old union rules used to be. If you laid somebody off or you furloughed them, you must bring them back before you hire new employees. That's the obligation under the right to recall basis. So if you're in one of those industries, please make sure that you're reading that regulation, you're familiar with it, because if you go out and you start hiring new folks and you don't recall your existing folks, there are significant civil penalties associated with that. Now I'd like to shift over and talk about the continuing.
Hey, Brian.
Yes, Holly.
I'm going to jump in there because I think you shift a little bit of topics, and we have had some questions come in here.
Okay.
So how, first thing, when you are looking to bring somebody back, and how do you do that report to the EDD? So that's pretty straightforward.
So typically, an employer is required to report when an employee is out on unemployment with a report of earnings or a report of reduced hours or reduced pay. That's a DE 2063 form. The problem is the third week into this pandemic, the EDD came back and said, employers, you don't even need to fill out the 2063 form. We're not even going to look at it. We're taking employees at their word. You still have an obligation, though, employer, that if you bring an employee back, you must notify the EDD. Why? Because if the EDD is taking the employee at his or her word and they certify that they are not working for a period of time, when in fact they are working for you, they're basically double dipping. That hurts you and that hurts the employee. So you do have an obligation to report that information to the EDD as soon as you've offered a bona fide offer of reemployment and the employee has either accepted or denied that reemployment. Now, is it the 2063 form that we've all known and loved for years? Probably not. What we're encouraging employers to do right now is to just send a letter with their EDD account number at the top of it and a list of all employees that have been offered bona fide reemployment.
All right, so when you are doing that recall of I'm going to read this, a temporary remote worker, and they don't want to come back because of their childcare, but they're not doing well working remotely, and you want them to come back, how would you navigate that?
Okay, so that's a really fascinating issue, and it's really unique to the facts of the circumstance. So please understand I'm not providing you specific legal advice on this issue because I would have a dozen different questions for you. But generally speaking, the way that I look at it is this. You have two choices. One, you either manage that employee to improve their performance when working from home, let them know and communicate to them what the expectations are of their performance. If they fail to meet those performance criteria, then you discipline them. You document that discipline, and it may even lead to an ultimate termination if they're unable to perform from home. The second option is to basically say, listen, we are now open for business. We do not have the ability to have you work remotely because you're not being efficient. You need to make accommodations for childcare. The concern on this issue is a discrimination claim potential, right? Because as I'm going to speak about in just a moment, as you bring employees back, we still have obligations to comply with the Families First Coronavirus Relief Act. That means that if an employee says, I don't have childcare, you may be obligated to provide them up to 12 weeks of paid leave for them to sit at home and care for their child. During that time period, they cannot telework. They're on a certified Family Medical Leave Act leave. And so what that means is you run that risk if you insist that they come back to work and they assert their rights, assuming that they're entitled to them, and we'll talk about that in a moment, because at that point, now the employee can just sit at home, draw 2/3 of their wage, and you're not getting any productivity whatsoever.
Okay.
But feel free to shoot me a specific situation because I would have some questions about that employee, the performance, whether or not telework is in fact a reasonable accommodation moving forward.
So this I think is more PPP related. Will the government take the employee's decision not to return into work into consideration when calculating head count?
Yes, yeah. So I'm sorry, I skipped over that when I was speaking about the forgiveness element. That will not count against you as your FTE equivalent calculations as long as you've offered bona fide reemployment to the employee. So it won't count against your numerology issue.
And if an employee leaves the company due to mental health issues, should an employee pay them through PPP or have them file for disability?
Great question. So the question becomes, is it a certified disability from a medical professional? If you have a doctor's note that basically says the employee needs to stay out for 2 weeks, 4 weeks, 6 weeks due to mental health issues, at this point, I am encouraging employers to keep that person on payroll in order to ensure forgiveness, because the problem is this. If you've got the work and that person's not normally able to perform the work, they would move on to state disability. But remember that the purpose of the PPP program was to keep people off of unemployment and state disability insurance. It was to keep people employed during this time period. So the intention of the monies that were given to you through the PPP program are designed to help that particular person out. So I would continue to keep them on payroll during that time period. Document every dollar that you're paying them. Make sure that you send a letter to them accepting the fact that they are not performing work at this time while they're under the care of a doctor, and that you will be carrying them through as part of your PPP program only for as long as the PPP program is in place. So in other words, if you are already 4 weeks into your PPP program, meaning 4 of your 8 weeks, and you've got 4 weeks remaining, but the employee is taken out for 6 weeks, you would pay them for 4 weeks, and then you would stop paying them, and they would have to go on to state disability insurance for the final 2 weeks of their leave. Obviously, the one thing that I'm not going to address on that issue is whether or not the mental health issue is in any way tied to the work itself, such as a workplace or occupational stress claim, because then that opens up a whole can of worms as it applies to the Workers' Compensation Act.
All right, I'm going to let you go on because we're going to go crazy on questions here. But I will let folks know that we are going to make the video of this available. I'll put that out in the chat. So, okay, Brian, back to you.
Excellent, thank you. So I'm going to be real brief with the FFCRA because I've done multiple presentations on this. Go back and take a look at those from the EDC if you'd like. But basically, as you bring employees back, if they have not exhausted their FFCRA benefits, 80 hours of paid sick leave if they themselves become ill or they're caring for someone who is ill and they've been quarantined, or the 12 weeks of extended family medical leave in the event that they don't have childcare within the workplace, that requires them to be paid 2/3 of their regular rate of pay while they're out. Both of those will still apply to employees who have not previously used those leave obligations. Remember that the extended family medical leave, if you are under 50, there may be an exemption for you. Please consult with your counsel to make sure that you have the information necessary to obtain that exemption, to document that exemption, and to communicate that exemption to your employees in advance. So just be aware of the fact that those FFCRA obligations that kicked in April 1, just because you've had your business shut down or people haven't used it, they may use it at any point between now and the end of this year, 12/31, December 31.
And Brian, quickly, the applicability of that act. Employers of what size?
Oh, I'm sorry. Applicability goes to employers with 499 employees or fewer. County of Los Angeles, though, has extended that. If you are an employer with over 500 employees, these are the thresholds. If you have 500 within the County of Los Angeles, it applies to you. If you have 1 employee in the County of Los Angeles, but 2,000 worldwide, the provisions of the FFCRA will also apply to you. The one sad thing about the whole extension within the County of Los Angeles is the fact that you, as a business owner, do not get to enjoy the tax credits that go along with the Families First Coronavirus Relief Act. You simply have the obligation to provide those leaves to your employees. Okay, so now let me get to the actual policy revisions, the things that you need to do before we reopen. Everything that's on this page is actually mandated by the state of California. Okay, you have to have these things in place before you reopen under the statewide stay-at-home order, whether you are stage 2, phase 1, phase 2, or stage 3, or potentially even stage 4 if you're a group gathering such as a concert venue. Okay, so first and foremost, we have to lay out a timeline for the anticipated return to work for your employees, including any expectations for modified work duties. What does that mean? As we get back and we find whatever the new normal looks like, many jobs are going to change. They're going to be fluid. I preach all the time that documentation is key in the employment relationship. It is the worst part of our jobs as managers, as leaders of an organization. We don't like disciplining. We don't like having written job descriptions. We like to give people freedom, flexibility, and the ability to move within jobs as needed. But at this point, it is absolutely imperative and essential to communicate to your employees what it is that your expectations are. What's the timeline for their return to work? You may decide that they're not able to return to work at 40 hours because you just simply don't have that work. You may bring them back at 20 hours to begin with, but you need to lay out what your expectations are so that they are communicated to your employees. Secondarily, if their job duties have changed in any way, shape, or form, it needs to be documented with the employee in advance. When you bring them back to work, send them a copy of their job description. If it's the same, that's great. If it's different, then you need to say where it's different and why it's different. There are certain circumstances, such as a large manufacturing companies, where we've got capacity issues. We can't maintain social distancing between these locations. So what we have to do is we have to actually stagger our workforce. We're going to run 2 shifts or possibly 3 shifts instead of just running 1, so that we have people coming in on a staggered basis. If you're changing somebody from a first shift to a graveyard, you have to put that in writing. You have to explain to them why it is, and you need to let them know how long you anticipate that change to take place. That's essential step number 1. Number 2, hopefully everybody already has cleaning and disinfecting protocols in place. What are you doing to ensure that the coronavirus is not landing on surfaces and the person who comes behind one of your essential workers is touching it or spreading that disease? What is your policy regarding cleaning at the end of the night for each employee's office, if you're in an office setting, manufacturing location, if you're doing that? How are you ensuring that people are washing their hands throughout the day repeatedly? Do you have disinfectant or antibacterial soaps and then the hand sanitizers with every person at every single work desk? Literally, you should have one of these at every workstation for every employee that you have, and you need to encourage them to use it. It needs to be a written policy. This does not need to go into your handbook. A lot of people have asked that question. Do we need to change this into perpetuity? No, we really don't. Now, do I think that this is going to become part of our policies and our procedures moving forward, even after coronavirus passes us? I do. But for now, until we figure out what our final rulings are going to be, what our final policies look like, keep it flexible, keep it moving, make it a memorandum that gets published to all of your employees so that they understand what the protocols are, what their obligations are in order to make sure that they're cleaning up their workspace or any common areas after they use them. And then you need to lay out your enforcement protocol, indicating that you are going to discipline employees in the event that they fail to comply with your cleaning or disinfecting policies that are in place. Third, social distancing. This is basically becoming part of our vernacular moving forward, probably forever. Whether it's 6 feet or smaller at some point, we don't know. Right now, the state is insisting upon a 6-foot social distancing radius around every worker. What does that mean? If you have a cubicle farm where there are tons of people working side by side 3 to 4 feet away, you're probably going to have to stagger those employees. You're going to have to spread them out. You're not going to be able to have somebody working within close proximity. That means that if you've got workstations, you may have to put up what we call sneeze guards, the plexiglass dividers in between workstations. If you have a manufacturing facility and people are working side by side doing manual labor, you will have to ensure that there are 6 feet in between each worker on the manufacturing or assembly line. These are all modifications to the existing work protocols that you must have. You have to have them in place, and I strongly encourage you to put them in writing so that they are understood by your employees as they move forward. Why? Because this is another policy that you must also have an enforcement protocol on. If people are congregating, let's say in a break room, and they're not maintaining social distancing during their lunch periods, you must take steps disciplining that employee up to and including termination. Be cognizant of the fact that if you're not taking these steps, you are in violation of the statewide order. The state could come in and penalize you both from a civil penalties standpoint, or they possibly could administer criminal prosecution. Do I think that criminal prosecution is likely? I do not in any way, shape, or form, unless you are a multiple repeat offender failing to take proper steps and protocols to protect your employees. Say that 5 times fast. All right, next, making sure that we have a general health and safety policy, including enforcement protocols. What does that include? That includes employee health screenings. Are you going to take temperatures as people walk in the door? The EEOC, Equal Employment Opportunity Commission, says that is okay in light of the current pandemic. Typically speaking, you are not allowed to take the temperature of your employees as they walk in. Why? That's personal information. You as the employer typically are not entitled to know the medical condition of your employees as they walk in the door. Because we're in a pandemic, we have a loosened restriction on that issue. Are you going to require people to sign a certification that they haven't been coughing, that they don't have any symptoms or signs of COVID-19, including a fever, as they're walking in the door? Perhaps it might make sense. taking steps to make sure that other employees are protected is your responsibility as the business owner, as the leader, as the manager of the organization. What individual control measures are you going to take? In the event someone comes into work and they are in fact sick, you're sending them home, right? Well, that needs to be a written policy, a written protocol. If you show up sick, we are sending you home immediately. And then the question becomes, are you going to pay them for the time that you send them home? Arguably, you don't have to, unless it falls under one of the protected provisions of the FFCRA. So you need to have those control mechanisms in place. Secondarily, how are you tracing who is coming in and out of your workplace on a daily basis, such that if you have a visitor, a vendor, a third party who walks in, and then they call 3 days later and say, oh yeah, by the way, I'm exhibiting symptoms. You will have an obligation to make sure you are contact tracing those individuals so that you can notify employees in the event that they need to self-quarantine so that they can be protected themselves. And then training. Training your employees is going to be essential. For those companies out there that only do trainings, you're going to be so doggone busy over the next 6 months. It's going to be remarkable. Why is that? We have to get in front of our employees and talk to them about what our protocols are, what our policies are, making sure that there is no plausible deniability. Well, I didn't know we were supposed to clean our workstation at the end of every shift. Of course you did. We put you through a training session. You came in, we took attendance, we confirmed that you sat through a 1-hour training on our cleaning, on our public policy, on our social distancing, and on our PPE protocols. These are essential elements that you will be required to maintain documentation of as you move forward in order to ensure that you are a compliant business with the statewide orders. Policies regarding the use of PPE, personal protective equipment. We all know that we're walking around day to day wearing our masks. Every single day we are obligated when we walk into another business, when we're interacting with other people, to wear masks. That is a statewide recommendation, a countywide order, and it has been reinforced here in the city of Santa Clarita as well. But how are we going to deal with this on inter-office interactions? Are you going to require that people walk around your place of business all day long with masks? Well, if they're in close proximity, the answer is probably yes. If you can isolate people, such as if you're in an office setting and someone can close their door such that they're not dealing with people on an hourly or minute by minute basis, you probably don't have to have them wearing their masks in their offices. Now, if you're going into a break area where people are using a common microwave, for instance, or a water station, should people be wearing masks because they're coming in and out of that common area and interacting with other people and probably not maintaining a full 6 feet of social distancing? Yes, that is a policy you should probably have in place if that is part of what is in your culture at your business. Dealing with the public, clients, and vendors. What are you requiring when people walk into your place of business? First of all, it should certainly be masks. There's no doubt about that. But are you requiring them to put on any other additional PPE? If so, you should have an announcement that's hung in the front window of your business or in a prominent location so that people can see it as they're walking in. Your obligation as a business owner, by the way, if you choose to reopen during this time period, is that you have an affirmative obligation to provide, maintain, and dispose properly of personal protective equipment. What does that mean? Well, nitrile gloves, this antimicrobial, antibacterial gloves, are technically considered a biohazard. You're not supposed to just drop those in a regular trash can. They're supposed to be put into a biohazard protective situation. Additionally, if someone is using a disposable mask and they become ill or they are exhibiting symptoms, that also is a biohazard. How are you going to go through and make sure that you are disposing of that PPE properly? That is your obligation to have a policy in place. And unfortunately, I've had a number of folks who have asked me time and time again, hey, listen, do you have anything off the shelf, a template that you can provide? And honestly, the answer is no, I don't. Every business is very, very different. What works in a small office setting is not going to work in a manufacturing facility of 20,000 square feet. And it certainly isn't going to work in a restaurant that's doing curbside pickup or delivery. These are really specifically tailored policies. So you need to speak to your internal HR person, an external HR professional, or an attorney to make sure that these policies are ready and raring to go before you open your doors. Why? Because if you open your doors and then set the policy, you're technically out of compliance with the statewide order. All right, Couple other policy revisions. These are best practices. These are not required by the state, but I want to touch on them nonetheless. Modifying your leave of absence or illness policies. What are you going to do to reasonably accommodate the individuals who have FFCRA issues? That includes people who have to stay home from work because they've got childcare problems or concerns, at least until childcare reopens again. And by the way, statements made yesterday at a national level are that schools are not going to be able to restart until there is a vaccine possible. It's a statement. It's by one member of the coronavirus task force. Is it possible that schools don't start on time in August as a result of this? Yes, there is. Does that mean that we as employers have to prepare for that and we have to be understanding on what the issues are for our employees? No doubt about it. Making sure that we've got those reasonable accommodations prepared and ready to go are an essential part of our jobs. Modifying our existing work from home or telework policies. I will tell you, 90% of my clients never had a telework policy before March 18th. Now they do. This is an important element. When are you going to allow people to work from home? When do they have to be in the office? Is this something that you're going to give great flexibility to? Also, if you are allowing telework, what are you doing to comply with all of the wage and hour requirements in the state of California? Are people still punching in and punching out at the beginning of the day and end of the day? Are they clocking in and out for their 30-minute uninterrupted meal periods? What are they doing to maintain safety protocols within their home so that you don't have a Cal OSHA problem or a workers' comp problem down the line? If you've got people who typically work in an office and they're sitting on a laptop on their couch, I'm going to tell you right now, we're going to deal with a lot of back injuries, neck injuries, carpal tunnel syndrome in the next 2 to 3 years if we don't have good policies in place today to protect against that. Modifying business travel policies and protocols. What are you going to do for your sales team? Are you going to allow them to get on a plane and fly around the nation, fly around the world to your clients? If so, and they do fly into an area that is known to have a high propensity of COVID-19, are you going to require them to have their own self-quarantine period so that they don't come back into your workplace and potentially transmit and infect everyone in your workplace? These are all essential obligations for you to make sure that you're thinking about, putting down in writing, and communicating to your staff and team so that they know what to expect. Statement banning retaliation. Employees who exercise their rights under the Families First Coronavirus Relief Act, under the Family Medical Leave Act, under any of these policies or protocols cannot be subject to retaliation by the employer. You can't come back and say, well, they were so difficult during the COVID-19 crisis that I'm getting rid of them. It just simply doesn't work. You will find yourself on the wrong end of a lawsuit in that circumstance. Issuing a policy or a procedure to report employee violations of COVID-19 policies. I hate this. I hate this more than you know. I don't like employees being whistleblowers on one another, tattletales, if you will. But quite candidly, you need to know from a management level when people aren't following protocols and procedures. So how does that work? Do people go directly to their manager? Do they go directly to HR to report this information? That needs to be clearly communicated to your employees. If it's applicable, you need to make sure that you're revising your drug and alcohol screening policies. I hate to put it out there, but this is one of those situations that I've been scratching my head on. People have been bored for the last 8 weeks. CBD products and THC products in the state of California are legal for recreational use. To suggest or imply that people weren't out there experimenting or having a little bit of fun when they were away from work, I think is naive. But what does that mean for safety protocols and security for your business? You still have a right to say you cannot come to work drunk or high on anything because of safety protocols and procedures. Are you making sure that you've got a fair and accurate policy that states when you're going to allow employees to do what they want on their own time? Are you going to re-screen employees as you quote unquote rehire them and bring them back from furlough or layoff? These are all essential things for you to think about. And then finally, these policies, each and every one of them that you publish to your employees, should always, always, always have a restatement of the at-will presumption of employment in the state of California. That means that you as the employer or they as the employee have the right to end the employment relationship at any time, with or without advance notice and with or without cause, so long as the reasoning behind your decision to terminate employment does not violate a public policy of the state of California. That at-will statement should be published in every single one of your policies so that people still understand that the discipline and the termination rights that you maintain as an employer stay intact and stay in play. All right, I put this up here one last time because I think it's important for everybody to remember, as part of your best practices, you are required to have these postings up. As we start bringing employees back, they must be in a conspicuous area, a place that is accessible by your employees that they can see regularly. We must make sure that we have our FFCRA poster posted up for all of our employees. I provided you the link here. Oh, I'm sorry. I guess I should have said this at the beginning. My PowerPoint presentation will be sent out to every attendee today, so you don't need to jot notes and write all this stuff down. You will get a copy of the PowerPoint via PDF, so all of these links will be included for you, so you can go ahead and have those at when the time comes. So,
Brian, we have added those to the EDC's COVID resource page, and I put that out in the chat.
Excellent, excellent. Thank you, Holly. That's lovely. All right, so all three of them are here, and they're also on the EDC page. I encourage you to go and visit that because it also has a lot of great other resources beyond what we've talked about today, including the prior presentations and the one that is coming up on Friday. And then finally, I sound like I'm beating a dead horse, but I think it needs to be clarified one last time. Communication with your employees at this time is not just an obligation, it is your top obligation. Communicating, letting them know what your policies are, letting them know what your thought processes are as they're coming back to work. Being transparent is going to be an essential part of how you keep your culture together, how you keep cohesiveness, how you instill confidence in your employees so that they know that they have a leader that they can trust and rely upon when dealing with a situation like this. Making sure that those policy revisions are being communicated, making sure that all these best practices we've discussed today are being discussed with your teams, all the way down to your very lowest level, line level workers, your health and safety protocols and procedures, and then finally, positive reinforcement. It sounds silly, and coming from the attorney, people laugh at this all the time. A little kind word about how much you appreciate your team, especially if they've been working at home, especially if they've maintained their productivity, especially if they've done everything that they can to kind of help keep the wheels on your business's bus. A thank you goes a long way, and it will instill a lot of confidence in your team. Don't undervalue it, and also don't think of it as, well, they already know that I'm appreciative that they do this. Your employees probably don't know. And a kind word right now will really bolster morale and the strength of your culture. So that is the end of the slideshow presentation. I know we have some more questions that I'll jump into, Holly. I'm more than willing to stay on the line if you're willing to keep everybody on the line and people can drop off as they need or see fit, but I'm willing to stick around and answer some questions for the next 15 or so minutes.
Okay, great. Thank you, Brian. So we do have a handful of questions here. Some of this kind of go back to your bringing back. First off, comments on letting parents bring children into the office. And then if the employee says no, can they use the I can't find childcare as a reason to not come back?
Okay, so first and foremost, I am not a fan of children in the workplace unless you are working in a childcare facility. That most businesses are not set up for a safe location for children. And I want to make sure I'm emphasizing something. You are assuming a liability as a manager, as a supervisor, as a business owner, if you allow a child to come onto your premises. If something happens and they are injured in the course and scope of their parent working, you are liable and responsible for those injuries. I don't like it unless it's a very specific and finite circumstance. If you have the facilities for childcare, great. Otherwise, children stay at home. So the second part of that question is actually far more interesting. You offer bona fide reemployment. The employee comes back and says, I can't come back to work. And then ultimately they use childcare as an issue. What's going to be fascinating about the timing on all of this is how the state's order is lifted on childcare facilities. And let me clarify. Childcare is actually included in stage 2. They moved it. It was originally in stage 3. Now it's in stage 2. But it wasn't part of phase 1 of stage 2. So while these businesses are beginning to reopen starting last Friday, a lot of employees have come forward and said, hey, I can't do anything about it. Let me just give you a couple of guidelines. First and foremost, if they have a minor child that is under the age of 14, we have a duty and obligation to accommodate. If they have a child in the home that is 14 years old or older, the presumption is that they are old enough to babysit their siblings and take care of themselves, unless there are special circumstances. If your 14-year-old has special needs, if they have emotional issues, if they are physically unable to care for themselves or others, you're not obligated as an employee to have that person care for your child. But if they're 14 or older, the presumption is that they can be cared for on their own and they can care for their siblings. But assuming for a moment we're talking about minor children under the age of 14, remember what I said earlier, which is that the FFCRA obligations for extended family medical leave will apply for employers that are bringing their employees back. So you have a question. Can the employees still telework? Can they, if you had them teleworking, is that an efficient use of their time? Or do we insist that they come back, they assert their rights, they're now out on a paid leave of absence for the next 10 weeks, such that you are in a position where you're paying them to sit at home and care for their child? Those are very difficult decisions to make. They're very fact intensive, and they should be done within the construct of discussions with your HR team and probably your legal counsel.
So another one about bringing people back. Sorry, I just lost it. If an employee's been working remotely at a reduced rate of pay and once they return to their full rate of pay, do you have to tell EDD? Kind of goes back to those questions earlier.
Yes, you do need to tell EDD that the employee has been restored to their full rate of pay when they are restored to their full rate. That means that the employee will no longer be eligible for supplemental unemployment insurance benefits through the state. They also will no longer be eligible for the $600 federal supplement.
And when people are bringing people back and employees have different responses, what if you don't think they're being truthful? I mean, you touched on it a little earlier.
What? No, employees don't ever lie. Well, listen, honesty and transparency, this is part of the reason that I'm encouraging it from your end of things, from a manager's end of things, because if you're being honest and transparent, then you have every reasonable right to believe and expect your employees to do the same. If you just think that they're being dishonest, I mean, you've got to be very delicate about how you approach this, right? Because there are certain things we can't ask about. We can't ask about medical condition unless, of course, it's tied specifically to COVID-19. We can't ask about what's going on in their personal life without invading their personal information. So you've got to be really delicate about whether or not you're calling somebody a liar or not, because what are you going to do if you're wrong and they were telling the truth? So be very cognizant of that, but to be bold and to be honest with you, as an employer in the state of California that has hired employees to work for you, you need to expect that your employees are going to take advantage of this circumstance. You need to assume that they're going to be less than fully transparent with you and possibly even dishonest in certain circumstances because it benefits them. You have a right to push them to return to work as long as it is reasonable under the circumstances, as long as you've taken the appropriate precautions and protocols to protect them in the workplace. If they come back and they say, I've got an issue, you can require them to provide it to you in writing, and then you accommodate that issue.
Are you allowed to require somebody to have a doctor's note for people to return to work? How might those type of protocols play in here?
So return to work certifications are only in those cases where an employee was away from work due to a medical condition. So if they basically told you back in March or early April that they had been diagnosed with COVID-19, you can absolutely ask for certification that it's safe for them to return to work. Similarly, if somebody had been out on any kind of workers' compensation leave or an injury, like they were in a car accident and they injured their back, you are allowed to ask for a fitness for duty certification, basically a certification from a physician that they can safely perform all of their essential job functions for you without putting themselves in harm's way.
And when they're coming back, if they're coming back to their original duties, do you need to restate those duties? Do you need to give them a new offer letter saying no changes?
Yeah, so obviously as we're reinstating employees, we do have to put it in writing. I actually like to use my offer letter. I think it really sends a new invigorated purpose for it. I like to republish job descriptions if nothing else, and again, remember, I'm the lawyer, right? The job description is only as good as the accuracy of what they're doing on a day-to-day basis, right? And this is a great opportunity for you that maybe they're not doing certain duties or responsibilities any longer. So why wouldn't you want to republish that job description? Why wouldn't you want to say, hey, listen, we're bringing you back to this job. Here's your job title. Hey, by the way, here's a list of your job description. Are you still doing these things? Are you still doing A, B, and C? Oh, you now have new duties. You have new responsibilities. Let's go back and edit the job description. I know no one likes to do this. I know the documentation element of the job sucks. But at the end of the day, guys, you will be better for it. It will put you into a more protected position. Third, it is communicating to the employee what your expectations are. Remember on that very first slide that I went over, I talked about setting employee expectations so they know what it is that you're looking for from them.
In terms of PPE, we had a couple of questions, and if you go back one slide, you have the CDC's website. I referred somebody also to the California Business Roundtable has some comments, and of course the governor's office recovery task force is coming up to them. So, but specifically, a question about assembly line PPE, and you talked about the sneeze guards, the dividers, et cetera. If they're wearing PPE themselves, sort of what's the level of, what do they need to be doing? Do you need to have multiples? Kind of maybe just cover it a little bit more for the assembly line one more time.
Okay, so on an assembly line, it'll really depend on how close the proximity is of your workers. I'm going to assume for a moment that you're maintaining social distancing protocols of 6 feet, and therefore you wouldn't need to have partitions or that sneeze guard, as I called it, in place. Masks will be sufficient. The question becomes, because people are touching multiple parts along an assembly line, do gloves become necessity? Yes, I think that they do in that circumstance. What do we do with gloves? How often do we change out the gloves? That really depends on the type of equipment that they're handling. It also depends on the products that you're producing. I have a manufacturer that, or not a manufacturer, basically an assembly line plant that does food service and foodstuffs. They require employees to change gloves every hour. So every hour, the whistle goes off, people go over, they take their masks off, they dispose of the masks, they dispose of the gloves, and they change them out because they're handling items that could be contaminated on a regular basis, and they want to make sure that they're limiting continued contamination. But really, it's a case-by-case basis, how close they are, what they're handling, what the transmission rate is of COVID-19 on the particular product that they're passing along on the assembly line in order to make your best practices decision.
And I got this question at first. I thought maybe it was a little bit of tongue in cheek, and then I thought, oh, it could be a person who has a difficult employer. And the question was, what if the owner doesn't want to comply with any of this? So maybe it's an opportunity to just talk a little bit about what do we think the sort of consequence and frankly litigation circumstances of this are. I know it's a little too early to know anything certain.
Yeah, so what we can talk about is we know that there are civil penalties associated with violating the executive orders. The civil penalties that are associated with that are fines up to $5,000. It also includes censure from several state agencies, including the Department of Labor. That opens up a can of worms regarding future audits and reviews of your policies and practices and procedures that aren't related to COVID-19. So I'm not a big fan of that. Secondarily, the criminal penalties can be restitution up to $1,000 plus up to 6 months in county jail for violating these orders. More importantly, I think the civil claims that would arise from your employees if you fail to provide the proper protective equipment or put the policies in place that are required by the state are more important, right? Because employees are going to come back and they're going to say, hey, listen, our employer has exposed us to liability. They've put us in harm's way as a result. We already know one aspect of it. The state of California has currently, it's a rebuttable presumption that if an employee comes to work as an essential employee for your business, and at some point they contract COVID-19, the presumption is that they contracted that illness at your place of business. I want you to think about that for a moment. The fact that they go to the grocery store and they're touching equipment, the fact that they had a barbecue on the weekend with 50 people in their backyard, the presumption is against you, the employer, in that circumstance, and it will increase your workers' compensation claims. I'll take it one step further. AB 168 has been proposed by Lorena Gonzalez, not a friend to businesses. I'll just say that. Her statement is that it's not a rebuttable presumption. It is a conclusive conclusive presumption. What does that mean? You cannot even submit evidence that the employee had a backyard barbecue the week before he got sick with COVID-19, where people were all sick with COVID-19. You're not even allowed to introduce that evidence. It is a conclusion that if they are working for you and they contract COVID-19, it is a workers' compensation protected injury. So that's that. And then finally, the civil claims that I began touching on briefly, claims of harassment or retaliation because somebody comes forward complaining that the boss didn't comply with one of these best practices or one of these required protocols from the state of California, and then they turn around and either get a demotion or reduction in pay, or they get terminated. These type of lawsuits are really going to keep lawyers busy for the coming 2 to 3 years.
All right, I'm going to give you a quick one, I think. A small gym, if you keep 6 feet between a coach and a client, do you also have to have masks?
Well, first of all, gyms aren't even part of stage 2.
When they open. When they open.
When they open in stage 3, we're going to have to see what the protocols are for gyms, because each county is indicating a very different protocol. I do believe it will be 6 feet of social distancing, probably with masks. I don't know that that's necessarily pragmatic while people are huffing and puffing, doing a high intensity interval workout. But hey, you know, that's basically the way that the government is looking at these things. And let's be honest, they are really not looking favorably on gyms right now, because they're high risk, high propensity to share germs because of sweat and proximity, etc. So do I think that they will require 6 feet of social distancing plus masks? Yes, I do.
Okay, and then last question, do you have a projection on minimum wage increases and whether there will be pauses on that?
Pauses? No, absolutely not. The July 1 increase for County of Los Angeles is going to go into effect. The January 1 increase at the statewide level is absolutely going to go into effect. I do not see this legislature, as currently constituted, making any changes to either of those.
All right. Well, Brian, I, as always, want to thank you for the insights, the fear that you instill, but no, you stay on top of this information, and it has obviously been changing so rapidly. So we appreciate you coming in and giving us all of this information. I just put up on the screen really quickly here some of the upcoming webinars. What I'm going to tell you, though, is go to, and please watch out for emails from the EDC and from the chamber, or go to the website scvedc.org/scaling-up, because these are going to change. We do know we have a conflict now with the date for the city and county. When we have elected officials, you can imagine that that is happening. So we are going to be doing a little bit of switching around of some webinars. If you are signed up, you will get a notice of what those changes are. So I apologize for that, but that is what we're dealing with. And then we do have webinars coming up beyond these. So again, stay tuned to the e-blasts or stay on the website there, Scaling Up, so that you can stay abreast of those. And again, I want to remind you just of other resources. Both the Chamber and the EDC have resource pages that are trying to consolidate these ever-changing orders and resources for you. As you look at scaling up, there are resources. The EDC operates a job board called Live Work SCV, trying to help our employers find workers who have learned they really don't want to commute. So please check that out. We are encouraging employers as they post for free. So please take use of that. Also, our America's Job Centers is a connection with the Economic Development Department and the Workforce Department. So they are they're trying to connect folks who are currently on unemployment back to jobs. So I want to thank you again for your participation this morning, your attendance, the great questions, and appreciate you. And we'll see you next time on our next webinar. All right. In the meantime, be well. Thank you so much.